Hello and welcome to Hammer Environmental. My name is Greg Hammer. Today I'm going to continue our discussion on prior converted cropland. If you didn't see the first one on the first edition, we talked about what is prior converted cropland, who makes that decision, how long does that decision last, and can you challenge it? So if you need those questions answered, go back and take a look at part one. Today we're going to focus on the use and management of prior converted cropland from an agricultural perspective. And we're going to talk about what you can do and some things that you got to be careful about. So first of all, let's talk about the management of a particular piece of property with PC designation. How do you manage it? Well, you can maintain any system that you have in place. So let's say you've got a tile drainage system on your PC cropland, and you know what? I got to fix an outlet. I need to replace some tile. And you already have that designation on your property. You do not need to go back to USDA and ask for permission or ask for another designation. That designation stays with the property. It does not expire. And so you can go back and do whatever maintenance that you need to do. Also, though, you can do what's called other hydrologic manipulations. What's other? Well, other is anything. If you want to impact the hydrology of that particular area, because look, it was a PC, which means it's got a history of being wet. And oftentimes farmers need to come back and they need to control that hydrology so it doesn't drown out the crops, or so they can get in at harvest time and get the crops off before it's too late. So understanding that you can go in, you can deepen your ditches. You got 3-foot ditches and it's not sufficient and you want to change the hydrology, you can make them 4 foot. You can make them 5 foot. You need more ditches than what you have. Yep, you can do that. You want to realign those ditches. You don't like the placement of them. You don't like the way that they're moving. You want to move the water in a different direction. Good to go. Not an issue. That does not impact your eligibility as a USDA participant. So keep in mind that this only applies to farmers who are eligible or want to be eligible to participate with USDA. There are some farmers, it's a small segment, but there are some who say, you know what, I'm not doing this. I don't want, it's too much hassle. It's too many headaches to deal with the federal government on these issues. I'm going my own way. And that's fine. They can certainly do that. They just aren't eligible to receive any financial benefits from USDA. However, they should keep in mind, if that's you, you're still subject to other federal laws like the Clean Water Act and other state laws that have regulatory jurisdiction over particular wetlands. So you need to be cautious of that as well. So now, what's the cautionary part for the farmer? Okay, so you come in and you do whatever you want, right? You bring in some fill, you crown a field, you put in a new ditch, you deepen something, and you've done your work to improve your property so that you can perform the tasks that you want to perform on that land. The caution is, let's say that you put in a perimeter ditch, all right? You put a new perimeter ditch and you're using it as an outlet. Well, that perimeter ditch, what is it going to do to the adjacent piece of property? So for example, let's say you've got an adjacent piece of property that is in woods, and that woodland happens to be a wetland. Now you may or may not know that, right? Do you know, is it a wetland? Maybe you do, and maybe you don't. But the cautionary tale from USDA in the manual says that you should be careful, because if you inadvertently impact that wetland, meaning that you drain it so that it's no longer a wetland, that could be trouble. Now, it's not trouble with USDA. That is not a violation for the Food Security Act, but it probably, or most likely, is a violation for other federal laws, like the Clean Water Act. So how do you know, right? I mean, how is a farmer supposed to know? And that's where things get really confusing, because it's not always easy to know what you're impacting and what that might mean for you. And then to kind of complicate things a little bit more, there was a section of a previous farm bill. It's called Section 1619. And what that did was it restricted federal agencies who work for USDA from informing other federal agencies or state agencies if they see a violation of some other law. So, for example, when I worked with USDA, I was an NRCS employee. There were times when I'd be on a farmer's field and I would see things that I know that's a violation of the Clean Water Act. There's a farmer who's putting fill in a wetland, real life situation. There's a farmer who's doing work in a stream. That's a real life situation. And they are violations of the Clean Water Act. As a USDA employee, I had restrictions placed upon me, and I could not inform those other agencies. I did not have the authority. In fact, it was a privacy issue. And that's the way that USDA wants it. They don't want their employees being out on a farm and acting as whistleblowers to other federal agencies because it takes away their credibility. It takes away the willingness of a farmer to work with the agencies involved. So that's where things kind of get really confusing. So now if you're a farmer, how do you know? Okay, I need this new ditch, or I want to deepen this ditch, but am I going to be in violation? Am I going to get in trouble with the Corps of Engineers or EPA or the state? And so what do you do? Well, you can go back to the USDA agency. You can ask for some advice, and depending on their workload, they may or may not be able to help you out with that particular situation. But in the end, they can't answer for other agencies. They can only speak for themselves. So as a farmer, do you want to go and ask EPA? Do you want to go and ask the Corps of Engineers, hey, could you come out and tell me if I'm in violation? That's kind of where you're at. And so oftentimes when I was working with USDA and I saw a particular situation, what I would do is I would advise the farmer how to fix that particular problem. And most of the time, that's exactly what took place. And the problem got solved, and it was the best result. But if you're in a situation and you're like, you know what, I'm not sure, and I don't really know. And sometimes the truth of the matter is some of our USDA agencies are so overwhelmed with workload that they just can't get to folks in a timely manner. So if you have questions about that, or you think that we could be helpful here, just give me a call. We'll talk about it and we can see if we can help you out. So hope this was helpful. Our next session is going to be focused on when there's a change in use. So this is going to be for the farmers, the developers, the consultants, and the lawyers, because it gets really interesting when it comes to PC cropland and a change in use. All right. Have a great day.